How to beat a possession case in Illinois. In Illinois, and this is true in most jurisdictions, there's really two types of possession. There's actual possession. I'm going to assume you're holding your phone right now, or maybe your laptop. You're physically in control of it. You're actually possessing it. Then there's another type of possession. It's called constructive possession. It's a legal theory that we've come up with to treat the possession of an item that may not actually be in your hand, but it's nearby. You have access to it. You know it's there. And though it's not actually in your pocket, it's not in your hand, we're going to treat it as if it was. And we call that constructive possession. Typically, when I have a constructive possession case, it's guns or drugs. The questions that I have for a prospective client is, well, where were the gun, or where were the drugs, and where was the gun? A lot of times we're talking about guns or drugs in a car. Was it your car? Where was the drugs or gun within the car? Did you make any statements? Would there be any fingerprints, DNA, gunshot residue that may be able to connect that item to you? Constructive cases are the easiest to win because we usually attack knowledge. A gun may be underneath your seat, but did you know it was there? Especially if it's not your car, the state's going to struggle to prove that you knew for sure that it was there. Active possession cases or actual possession cases are more difficult because they're actually in your hand, they're in your waistband, you're in your pocket, they're in your bag. That's difficult to prove because knowledge is assumed. So then we have to attack those types of cases on other Fourth Amendment grounds that it was a bad search or a bad seizure. So even if you had that gun or you had drugs, if they didn't have probable cause to stop you or search you, we can win on the legal technicality at that point. But in Illinois, actual or constructive possession and different ways to attack both.